Hello, IP friends, and welcome to Hashtag IP series with your favorite podcast host, Rita, and we're reaching the. If you are a first time listener, you are welcome. I hope you find my podcast interesting. I hope you learned something, and don't forget to subscribe and favorite my podcast so you don't miss out on any other juicy episode. Trust me, from the very first episode up to this one, keep giving you guys back to back interesting conversations. For my returning listeners, I love you guys. I appreciate you. You guys are just the best. Thank you for always coming back to listen to my podcast, and please don't forget to share your best episode with your friends and contacts. Now, we talk about recent cases and developments, trends on copyright, trademark, patent, industrial design, trade secrets, geographical indication, and plant variety. And for today's episode, I have a guest who will be talking about one of the types of IP that will be beneficial to SMEs and startups. So yeah, stay tuned, guys. So I was talking about my guest for today. He is versed in patent, which deals on invention. So if you're an SME or a startup, a business owner, please take this episode very seriously. Like, trust me, guys, once Tom starts to talk about patents in the United States, you would take your inventions and creations more seriously. So let's meet Tom, guys. Welcome, Tom. Please tell us what you do.
Sure. So my name is Tom Bassolino. I'm a patent attorney in the United States. I own my own patent law firm called Bass Patent Law, located in Frederick, Maryland. For those not familiar with Frederick, Maryland, it's a suburb of DC or Baltimore. It's about 45 minutes travel northwest of Washington, DC. I am a mechanical engineer by trade. I actually was a mechanical engineer in New York City for about 5 years before transitioning over to patent law. I worked in a big law firm in New York City for a number of years before bouncing around to a boutique and then eventually starting my own firm. So that's a little bit of a background on me and what I do. Our firm, I should say, there are kind of two types of patent lawyers in the United States. And sometimes they do both of these things, but usually you do one or the other, where you're either a patent litigator, meaning that you're in court arguing cases, on behalf of either people suing people for patent infringement or people defending against patent infringement. That's one type of patent attorney typically. And then the other type is someone that does what's known as, in the United States, patent prosecution, which is drafting patent applications, filing them with the patent office, and going through the back and forth of the examination process to try to get clients issued patents, and then all kinds of services related there too. And I am the latter. So I am, my firm specializes in patent prosecution. So our bread and butter is drafting patent applications and then filing them in the office and trying to get them through. But we also manage global patent portfolios and do all kinds of other kind of related services like freedom to operate searches and reviews, patentability searches and reviews, patent portfolio due diligence, litigation support, but not actual litigation. And that's kind of it. Our technology background, I should say. My technology background, obviously mechanical engineering, but what I like to say is that we practice in anything other than biotech and pharma, because I've worked on my fair share of electrical engineering related inventions, electromechanical inventions, software inventions, basically everything other than biotech and pharma.
Wow, I mean, that's mind blowing. I mean, like I think it's rare to find someone who's not a lawyer that has a background in another area of law, because it seems like IP or intellectual property is just reserved for lawyers. So you did mention patent prosecution. How would you say patent is relevant for small businesses before thinking of the litigation aspect, or even considering whether someone is actually infringing on your invention? What is patent and how is it very important for entrepreneurs and small businesses?
Sure. So to answer that question, I think it's helpful to sort of take a step back and explain what a patent is and what it does or is supposed to do, at least. Which in the U.S., and again, I'll put the caveat here that I'm a U.S. patent practitioner, and so my knowledge base is mostly in United States law. And although we manage global portfolios, so I have some knowledge of the patent process in other jurisdictions. My main source of knowledge and anything I'm ever able to give advice on should only be pertinent to US law. So anyway, a patent is meant to protect inventions. That's how you differentiate it from other forms of intellectual property, like trademarks are for branding and copyrights are for creative works. Patents are to protect inventions. And what they are meant to do is to exclude others for making, using, selling an invention for a finite period of time. That's the patent term, which in the US is typically 20 years from filing of the patent application. And if you're lucky enough to get a patent, then you can essentially have a finite monopoly over that invention for that patent term. So the trade-off as far as the US government is concerned is that all patents are eventually published. And so if you're putting out there your innovation, your invention, then others can improve upon it and we can further, innovation and entrepreneurship as a society. And the benefit or that the government gives you for doing that, for disclosing your invention, for saying, here, society, here's what I've invented, is that if your invention meets the criteria for patentability, then they'll get a patent where you can then preclude others from making, using, and selling an invention. So for companies big and small, it can be really valuable if, say, you manufacture widgets and you want to prevent your competitors from manufacturing the widget that you are manufacturing and selling. If your widget meets the criteria for a patent, you can file a patent application on it. And if you get an issued patent, you can basically preclude others from doing it for maybe a whole 20 years, which if it's a valuable product that you're selling and you can prevent all your competitors from selling it also, you can create that monopoly for yourself. One thing I'll also put a caveat on it too is that a lot of times when you hear patent practitioners speak about patents, they mention all the good things about them, which is easy to do, and we're biased to do that. But patents aren't for everyone. They are generally a very powerful legal tool, but also a very expensive legal tool to get, for better or worse. And so in a lot of cases, sometimes small companies or entrepreneurs or pre-startups or startups, it may be in their benefit to not file patent applications and to just get their invention out there into the market. That's kind of counterintuitive for a patent attorney to say, but I'm not naive to the fact that budgets are very constrained in the beginning of companies, in the early days of companies. And so, and since the patent process can be very expensive, you may want to reserve that budget for other areas. It's always a fact-based scenario though, and that's more of a business decision than a legal decision. But I always like to, when I speak to entrepreneurs and entrepreneurial groups or innovators from US or anywhere, I always like to remind them of the fact that like a patent may not be the answer for your company. It may not be a valuable tool for your company. And you really have to take it on a case-by-case basis.
So how do you know when patent is the best form of IP for your company or your brand? I know you did mention that it may not be advisable for startups to consider patenting an invention and just take the risk and put the product out there. But then how do you know that your patent is really valuable to be able to, give it some legal backing in the US or from an international perspective?
Yeah, so that's an awesome question. And it's a tough one to answer other than to say the self-serving answer of speak to someone like myself, speak to a patent practitioner, and they can give some insight into whether they think, one, whether you have a chance at all to get a patent, because, right, you don't want to really throw good money at a bad idea or a bad patentable idea, because there can be a great business product, idea, service, whatever, that maybe is not good for patents, and vice versa. That could be something that would be a slam dunk to try to get a patent for, but maybe it's not a good business idea. And so those things are separate. But it's always best to, early on in the process, kind of contrary to what I said before, to speak to a patent professional if you have something that is an innovation that you think is an invention that hasn't been done before, or it's an improvement, a significant improvement, I should say, on other things that have been done before. Then you may want to consider getting a patent, especially if it's easily copied by competitors. And so if you want to preclude your competitors from doing that, you should consider the filing of a patent. And the reason why I said it's good to early on have these discussions is because selling your product, offering for sale your product or service or whatever you think you may have, the potential to get a patent over, if you publicly disclose it, or if you offer it for sale, or if you actually sell it, that could preclude you from filing a patent application. And in the United States, we're actually fairly inventor friendly, where we give inventors a 1-year grace period after any disclosure, offer for sale, or sale of an invention to file a patent application for it. So those are known as statutory bars. That year period is known as a statutory bar, meaning that if you wait a year and a day, in theory at least, you are forever precluded in the United States for filing a patent on that. And so if you have publicly disclosed your invention, you start that 1-year clock. And we're kind of a little bit unique in the United States in that sense. There's a few other jurisdictions worldwide that have grace periods, but many, and most, I should say, do not. Like Europe is a good example of where any type of public disclosure of an invention could and probably will forever preclude your right to file a patent application on it. And so the rule of thumb that I really like to preach and emphasize, and if there's one takeaway from your audience in the global community, is that you should keep inventions. If you think you have something that is a valuable invention, you should keep it a secret as long as possible until you've either spoken to a patent practitioner about whether you want to file a patent application, or you have actually filed a patent application, because any types of those public disclosures or offering it for sale even can be detrimental to filing a patent application, and can in some instances preclude you forever from the ability to file for a patent application.
Wow, I mean, it's insightful, but then a bit scary, because one, you say registering a patent is expensive, and I know talking to a patent attorney is also going to cost you a lot of money. So how do you bridge the gap where you have to service the startups and the entrepreneurs, and then comparing them to the bigger brands who are already established and know that, okay, if I have an invention, I have to do the needful in terms of registering it. Now, let's say, for instance, you've done a registration and the term of duration is about to elapse. Is there a strategy you would advise, or any insights you want to give entrepreneurs in terms of extending their term of duration?
Yeah, so those are two different questions, and they're awesome ones. So let me answer each individually, at least attempt to, but steer me back in the right direction if I go off course. So the first question, Rita, that you asked was an awesome one, really, because it's the conundrum that a lot of entrepreneurs and small businesses and startups and pre-startups find themselves in, which is, how do I, if publicly disclosing or offering for sale or selling my invention, which is potentially patentable, and I want to maybe try to protect, if that could preclude my right to file for a patent application, and that is expensive to do, like how do I generate the revenue in order to file a patent application? And honestly, there's not a simple answer to it. There are some tools that can be used by inventors that are cheaper than the standard filing of a patent application, which I typically advise clients to do at early stages, especially when budgets are tight. And so in the United States and in many other jurisdictions, and I should actually take a step back and explain why I keep saying in the United States or in other jurisdictions, is because patents are territorial, right? And so a US patent only protects activity within or imported into the United States. So if I only have a US patent on my invention and someone is infringing it in, let's say, Germany, and they're only in Germany. They're not in commerce, in the United States. They don't import, they don't export into the United States. They don't touch the United States at all. There's really not much I can do about it. And that's a decision that every patent filer has to make, of like what jurisdictions are important for them to protect. So that's the reason why I keep saying jurisdictions or territories, is because of that. Like the reason is because patents are territorial. But anyway, so in the United States, there is a tool called a provisional patent application, which is an informal type of filing for the sake of getting a filing date for reasons like going out and seeking investment, selling your product to raise money for a more formal patent filing, which is called a non-provisional, which would follow. And you can do research and development, try to perfect your invention or design. There's many reasons why one might file a provisional application, but many times it's really for the sake of getting a filing date in a cheap or cost-effective manner, much more so than filing the full-blown patent application, which in the United States is called a non-provisional application. And so the goal of a provisional application, though, should be, in whatever form is best to do so, to submit to the patent office something that describes your invention fully in a way that would, enable someone else having a similar skill level to the inventors to be able to make and use that invention. If they haven't met that threshold, then a provisional application is worthless. The reason why I say that is because the colloquial example that patent attorneys in the US usually give of how informal a provisional application can be is a sketch on a cocktail napkin. Like, in theory, you could have a sketch on a cocktail napkin, you could file that in the patent office, pay $150 for a small entity, which is not much in the patent world, and you could be patent pending on whatever you disclosed on that cocktail napkin. But as you may imagine, it'd be pretty hard for most inventions to fully describe an invention as a sketch on a cocktail napkin. And so a provisional application should be, in my view, more robust than that filing. But it is, as I said before, the filing fees are very cheap, and you can do it with relatively little legal hand-holding, as opposed to what's required for a non-provisional patent filing, which does have many formal requirements, and a cocktail napkin would not satisfy those requirements whatsoever. And so that is one of the tools that can be in the toolbox of smaller companies and entrepreneurs for filing a patent application in a somewhat cost-effective way. And so that's like one tool. Another tool that they could use is trying to seek investment, but still maintaining secrecy. So having potential investors sign non-disclosure agreements before you show them what you have, and then seeking investment that way, making sure that it's not a sale of the product itself, but more of an investment in the company or the inventor. And so that is a way to circumvent, the on sale bar that I mentioned earlier. But again, the best practice is to actually have a patent application filed before you disclose it to anyone. But I know in a practical world that sometimes is not easy to do. So before I move on to the second question, though, I want to make sure you don't have any follow-ups or you want me to clarify anything there, because that was a very important point.
Okay, so I think what I wanted to ask as a follow-up question, I know you mentioned about signing an ND, and I have a very different view when it comes to signing NDs, especially for entrepreneurs, because one, you sign an agreement and then someone breaches the contract, or someone improves on your invention. So it means your invention and the money that was put in is no longer relevant. What would you do in that instance? Because it seems like NDA is supposed to save you at some point, but it's basically not doing that even with the provisional patent application that you're supposed to be doing.
Yeah, so there's not a real good answer to that question, which is a very good question. And it's one that brings in real world items into like a perfect ideological, like legal explanation, right? Because you're right. Like an NDA is just, at the end of the day, a contract that can be breached, and your repercussions for that are always expensive. Like, you have to sue and try to get back that money somehow of whatever could have been lost by the breach of that non-disclosure agreement. and that legal battle can be challenging. And so, and it may not solve the problem. Like there's not really, as far as I know, at least, a really good exception to that disclosure rule, even if there's some nefarious things that go on. And so it can be tough. I mean, the only best advice I could be is, or could say, is to be very careful, and try to vet as much as possible. Try to research as much as possible who you're dealing with, and see if they're reputable, and try to get referrals from them, other people that have worked with them. And again, this is all kind of challenging stuff when resources are tight, when networks are smaller, when you're just starting out. You may not be able to do all of that. And there comes to a point of where you just have to take some risks in business, and that's just one of them that you'll do. What I will say though is that, if you do have an idea that you think could be a patentable invention, like that's probably not in and of itself a business. You should have a business plan formulated around that. Like, how are you going to monetize this patent that you may file for? Or how are you going to monetize this product or service or whatever you think the patent should cover in a way that generates revenue that could potentially pay yourself back for the expenses incurred for filing patent applications? And so like a thing I like to say often to client or new clients or potential new business is that, you wouldn't buy a $10,000 safe to protect a $100 painting. And patents are kind of the same way. They're very expensive legal tools and can be very powerful legal tools, but the juice has to be worth the squeeze, meaning that whatever it's protecting has to have some pathway to monetization so that it justifies those great expenses that a patent application or patent family of applications.
Or let's move on to the next question, which is
Sure.
on patent prosecution.
Mm-hmm.
So, what would you say is the best form of dispute resolution when it comes to patent infringement? Would you advise an entrepreneur to opt for a court proceedings or an out of court proceeding?
Yeah, so I have a very probably biased view on that, but the short answer is out of court for sure. And the reason is because I've kind of said a lot about the patent process as far as patent prosecution is concerned being very expensive, and it is, and I stand by that. Well, whatever envisionment that your audience has of the patent prosecution process being expensive, times that by 100, and that's what you're dealing with patent litigation, and it's probably actually more than that. Patent litigations and litigation in general is absurdly expensive, at least in the United States, and as far as I know, in most jurisdictions worldwide. Attorneys' fees are a nightmare, and patents cases are usually pretty complex, and there's a lot of necessary steps that go into it. The court is usually pretty slow, and so you're in it for a very long time. And so I would almost always try as hard as possible to settle things out of court. And there's some data on this, but it's like, last I looked, it's like over 95 or 98%, I think, even of at least US patent litigations are settled outside of court anyway. And for that reason, no one really wants to pay these like crazy fees for the lawyering and all the other nonsense needed for a full-blown patent litigation that finishes in a jury or a bench verdict. And so, yeah, it's tough too, because like, as I said before too, about the patent process being expensive, enforcement is even more expensive, as that alluded to. And usually your potential infringers know that. And so it can be a challenge if there's someone out there, if you have a patent on your idea or invention and someone is out there infringing it, like, what do you do? I mean, the first thing you do is you should speak with a lawyer, because they should anything you do, you shouldn't be doing things on your own that could be detrimental to your own rights. But usually that process starts with a cease and desist letter sent to whoever's infringing. And sometimes they just stop, and then it's kind of all done. A lot of times they won't, and then you have to be a little bit stronger about it. There's some things that you can do there. There are also some, there's actually some ways that you can raise money for just the sake of filing lawsuits. And so there are like lenders out there that will, if you have a credible case, like fund your litigation. And so, but I honestly would never want to go onto those steps before trying to exhaust all of my out of court options first. And usually that can be as simple as talking to whoever is infringing it and working out a deal. There was something that happened early in my career when I was working at the large law firm, and it was basically two French companies. We represented one, and I was on this call with all the lawyers, and the two companies were on the call too. We had our client had sued the other company for patent infringement, and it was quite funny where the other company was very taken aback by the fact that we had filed a complaint in the court alleging them of patent infringement without calling them first. And they actually kicked off all the attorneys on the call, much to our dismay. And I had not known, I was so early in my career, I didn't know if this was normal or not. That's not normal, by the way. But they had kicked all the lawyers off the call, and then worked it out themselves and saved themselves probably a boatload of money in doing so. And so I'm sure the law firm that I worked for wasn't very happy with this outcome, but the client was, and that's really all that matters. And so, yeah. And so I would try to exhaust all out of court options possible in the case of where, you know, you think someone's infringing a patent of yours.
Fantastic. So, I know when you were introducing yourself, you talked about being a mechanical engineer before becoming a lawyer. How was the transition? So let's say there's someone out there that wants to transition into an IP practitioner, maybe a patent attorney. Was it very smooth for you, or you had a little bumps on your way while transitioning?
Yeah, so it was an interesting turn. So first and foremost, if someone's in a similar position, right, they have some sort of technical background of where they could go into patent law. At least in the US, it's a requirement to have a patent or to have a technical background if you want to be a patent attorney, an actual labeled patent attorney, which means you got to do patent prosecution, what I do. But I should put the caveat that there's no such requirement to be a litigator. And so litigators can have any sorts of backgrounds. And some of the best patent litigators I've ever worked with, frankly, didn't have technical backgrounds. And so that is not a requirement to do litigation. But for patent prosecution, for doing what I do, for actually becoming a labeled patent attorney, you do need that technical background. So first and foremost, I wouldn't delve into law at all unless you are very proficient at reading and writing and you enjoy it, because you're going to be doing a lot of it. And so the reason why I got into patent law is that the seed of patent law got planted into me when I was in college and university and studying mechanical engineering. And a professor noticed that I was a much better writer than a lot of my peers, my classmates. And that's frankly a low bar for engineers to reach, because many are not very good writers whatsoever. But he had noticed something in me. And so he actually tried to get me interested in patent law. And I thought it was interesting, but I wanted to be an engineer. And so I knew that. And so when I was in New York City, in a big city, being an engineer, I was working in construction. So I was doing basically the design of mechanical and plumbing systems and fire protection systems for high-rise buildings, for skyscrapers that were new and being built. And it was very, very cool, because I got to go to these construction sites, see these buildings, see the inner workings of them, design these systems, see them actually put into place, which was it's awesome. It's still awesome to this day when I go back to some of these buildings and see just like little silly stuff that is in a certain location because I put it there in a drawing, and that's cool. But honestly, it got a little redundant for me because I was doing honestly, once you've kind of designed one, you've basically designed them all. And so I was just kind of repeating it over and over again. And that to me, I wanted something a little bit more challenging. And so the way that I went into it was I took the test to get into law school, and I did okay. And so I got into a few law schools. I picked one that was right by my engineering firm, so I could, and that had a night program. So I worked during the day as an engineer and then went to law school at night. And frankly, I had the mindset of being very open of, okay, if I don't like this, I'm okay with leaving it behind me and either pursuing my engineering career or making another pivot. And so that's another piece of advice I would give to people just in general, is to be flexible and take opportunities as they come. But anyway, so I actually did enjoy it. I did pretty well with it. And so I thought, okay, this could be a calling for me. But another place where I made a big career pivot that was a little bit unforeseen was that when I got recruited by the large law firm and I started working there, I had thought that I wanted to be a patent litigator. I thought I wanted to be a courtroom attorney. But when I got exposed to the litigation process, I was very much turned off and I didn't like it whatsoever. And so I made the transition within the law firm to try to only focus on patent prosecution, on drafting patent applications and prosecuting them in the patent office. And I enjoyed that a lot. And the reason why is because I got to use my technical background a lot more. I got to really delve into these inventions and figure out how they work. And I really enjoyed that. So, I mean, I don't know if there's advice there, but sometimes I just like to kind of tell my story because sometimes people can see some reflection on a part of that story in their own lives or their own decisions, and maybe it can help them make their, their choices.
That's great. So, what would you say are the trends in the patent industry or sector that entrepreneurs and startups should be on the lookout for?
Yeah. So first and foremost, you may hear, especially if you're interested in IP, that like patenting software is become a little bit challenging lately, and that is true. As far as it used to be almost a sure thing, and now there's a little bit of a gray area, at least in the United States, and sometimes in some other jurisdictions too. I know Europe has their challenges with patenting some software,
Would you
but
say this is because of the Google Oracle case?
yeah, it's so in the United States is this Alice case is the big one, but there's a bunch of others that kind of follow that script. But it's Alice versus CLS Bank, if anyone's interested in reading a horrible Supreme Court decision. But that, yeah, since that decision, it's really rocked the boat in the United States as far as patenting software. But we're coming around to figuring it out slowly but surely. There still is horrible case law out there. There still is bad examination going on as far as software is concerned, but it doesn't change my view in that software is, like, I mean, this is saying something that's pretty clearly obvious, but software is the future. AI is the future. And so I think inventions are going to trend that way. I think the Internet of Things is making it trend that way, where even the simplest, purely mechanical inventions have a software twist to them. And so that would be the trend that I would be focused on.
So, final words and parting words for us, and how do we reach out to you if we have questions or if we need to consult you in the US?
Yeah, so I think honestly, like one of the bigger takeaways, if I had like big takeaways here, it would be clearly I've emphasized that the patent process is an expensive one, and that can be unfortunate for a lot of entrepreneurs and small companies. But there are resources out there to help you with that, and so I would encourage you to check out, the at least in the United States, the USPTO has database for seeking, pro bono services of IP attorneys, as well as some opportunities for, let's say, like minority-owned business, women-owned business, things like that. If you're older, there's some resources for that as well, where you can save some money, and so utilize those and research that. That would be one thing I would want people to take away. Another thing is to further emphasize the importance of, if you want to seek patent protection for an invention, of trying to keep that invention secret until you have filed a patent application, and recognizing that that can be challenging, but it's still an important thing, at least in the legal sense, to try to keep your invention secret before you have filed a patent application on it. And then if anyone has, questions for me, they can reach out to my law firm. Has an active Twitter account, which is how I met Rita, which is great, at Bass Patent. I give a lot of pseudo-free patent legal advice and/or like funny quips about patent law. At least I think they're funny. And my paralegal uses it every once in a while too, which is great. But otherwise, yeah, you can find me on my website at basspatent.com. Info@basspatent.com is how you can reach me via email. But that's kind of it. But I would just say, like, to emphasize again, it can be discouraging to hear that, oh, I'm interested in getting a patent, but it's really expensive. But good ideas find a way of generating revenue. And so I would just advise people to try to utilize their network as much as possible, try to build a network as much as possible. It sounds so like common to hear, but it's so important. Like, it's really nice when later on in your career, you can kind of think about just a sea of people that you can go to for help or advice or counsel or whatever. And it's great, or even like investment, things like that. And so you build that over a number of years, but the way you build that is by actually having these relationships. And so you have to kind of put yourself out there for that, which can be scary for some introverted people. And I get that, but it doesn't make it any less important.
Great. So we've come to the end of our recording.
Perfect. Thank you so much. Yeah, thank you for doing this. This is great stuff. I'm really glad you did it. I really did have a good time. And if you ever wanted to have me back, like to talk about a specific topic or not, I'm happy to do so. As you can tell, I can talk.
Yeah.
Probably my wife would agree with that, and probably in a bad way. But like I can fill airspace. So if you ever need anyone, feel free to reach back out. This was fun.
Thank you. I'll take you up on that